Hello, sir. How are you?
So, Ms. McCoy, let's talk about something funny.
Okay.
Actually, it's not very funny, but it's actually quite sad. Your lawyer came to me, was it yesterday or was it the day before, asking for a PR bond?
Monday.
Asking me to give you a PR bond. Do you think that was a good idea? To give you a PR bond?
Are we looking at the history?
Hey,
Okay.
we've never, ever once appeared on your own here when we give you a PR bond. Every case that we have with you sits at around 10,004, 10,005, because you never appear. When you come to court, good things happen. Do you understand? If you ever need help, if you need a place to sleep, if you need food to eat, if you need a cell phone or tablet, anything you need, all you have to do is come and ask, and we will bend over backwards to help you in any way that we can. But when you continually fail to appear, you become a flight risk, and we just can't trust you. So he came to me asking for this PR bond. I laughed because I know if I give you one, like little wings on a bird, bye, you just don't come. Next time, if you pick up a case, come and we'll help you with whatever you need. I don't care what it is, anything you want, I'll give you. You want treatment, you want help, anything. You now stand charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement where they're offering you 30 days in jail with credit for the 12 days that you've done. You're giving up a lot of rights by entering into this agreement, Ms. McCoy. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. You know, you've spent the better part of the last 4 years in and out of custody for one thing or the other. Before you know it, 20 years will have passed and you will end up in such a bad place. You're going to look like the things on the street that you'd never think that you would be if you continue at the rate that you are. You need to change before you really do some damage that you can't crawl out of. How do you plead to the criminal trespass? Guilty or not guilty? It's all right. You know what we're doing, right?
Do you want me to talk to her for a moment? I don't.
No.
Okay.
I mean, your plea, you know what we're doing? We're doing a plea for guilty, right?
Mm.
Is this what you want to do?
Yes, sir.
All right. All right, ma'am, I'm going to find you guilty. I'm going to follow the agreement. Come back next time. All right, good luck. Thanks.
Very good.
Was it 13 days credit?
12.
Oh.
I didn't. Mr. Crocker,
Okay.
he's not here.
Okay.
He's a bond. He has a surety bond. I called his bond company. I called his dad. I called him. Can we roll it till tomorrow?
Sure.
Okay.
Set BF tomorrow.
Okay, thank you.
No, sure, tomorrow.
I got you. Thanks.
Oh,
Miss Levy.
okay.
So I wanted to address the BDR.
Where is Miss Levy?
It's right there.
Come up, ma'am. So here's, Shreya, here's what we're going to do. I'm going to send her for a drug and alcohol test now.
We already did. She came back negative, Judge.
Oh, great. Good job. But if you miss again, it's not going to go well.
So
It is your responsibility to let Shreya know if you're going out of town, if you have some other obligation, because we can always work something out. But I'm not going to continue to do this. If you miss again, it's just not going to go well for you.
So Judge, that's what we want to talk about. So when I was first appointed to her, Ms. Levy talked to me about her work schedule. And I said, look, let's just wait and see what happens with the UAs. If you get called in for a UA, but you have work, I don't want you to lose your job. I told her that.
Yes.
So
They give you a sufficient amount of time to
that
come.
same day.
Yeah, I think 6 hours.
Yes. So she's a behavioral technician at Action Behavior Center.
Yes.
And she cannot take off work.
They said the last meeting.
So, and do you want to talk to the judge about that?
Yes.
I bought some printouts as well on my work's attendance policy. So we have like a 2 weeks ahead of time type thing. They'll let me off. I had to beg and say it was like a life emergency just to get Thursday. I also have asked before because I remember the original court date was for Tuesday, the 18th, I believe. And 2 weeks ahead of time, that court date, I wasn't scheduled to appear. And I said, since I missed that UA, would it help for me to appear in court that day, even though I'm not required to come, to show that I'm okay with appearing to test? Testing is not something I'm trying to avoid or anything, but if I can put, time and effort into make my appearances, be here, and also keep my job security, is there a way that we can balance those two things? Because I have no problem showing up and testing or anything like that. I also live in Humble, Texas. So traffic times, I get off work anywhere between 4:30 and 5:30 every day. And I did bring some printouts just in case that's needed of our policies and everything.
I'm not going to take off the fact that you're not supposed to use alcohol or drugs.
Right.
Absolutely. But is there a way we can schedule her testing? Even if you want
And
her,
that defeats the whole purpose of it being random.
I know.
Because that's how we catch people. If you know when the test is going to be, it defeats the purpose of it being random. So why don't we do this? Why don't we just work something? If you get called on again, call Shreya, and then Shreya can come to me, and then we can work something out somehow.
Okay, and every single time I will need your work schedule.
Yes, and I have printouts
So
from the
just
missed date as
send
well.
called on, let Shreya know. Shreya can come to me, and we can try to work something.
Okay.
Okay? Because I don't know, you may not get called again. I don't know. You probably will because you missed now, right? But just if and when they do call you, let Shreya know, and we'll try to work something out. Okay? Okay. Good luck. Yes,
Okay,
ma'am.
and then we'll just get a reset on
Let's
this.
get a reset. And your appearance is no reason for you to come, unless, of course, there's a.
So, and I say that, but your appearance was waived, but then when you have the UA, because you can't go to court, then you're gonna have to show.
Okay. Yeah. Mhm.
Okay. Good luck.
Thank you.
Have a seat.
Good morning, Mr. Rivas. Good morning. Sir, you're charged with interference with the duties of a public servant. You're also charged with possession of marijuana ×2, right?
Yes, that's correct, Judge.
So I guess both of the weak cases are being dismissed in exchange for this.
Yes.
You need to understand, Mr. Rivas, that this case is going to go on your record. It will be there for the rest of your life. From now on, you are facing a minimum of 30 days in jail for any new cases that you pick up. Do you understand? You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, like I said, it's going on your record. It'll be there forever. This is what you want to do.
Yes, sir.
I plead to the offense. I'm going to find you guilty. I'll send you to it. I'll run your court costs so you won't owe anything. Good luck to you, sir.
Thank you, Judge. Have a good day. Step over here.
Ready? Yes, Judge. And he's going to come in and sign the conditions tomorrow. I just wanted to talk to you about it beforehand so I could tell him what they're going to be.
Oh, okay. What's your cost?
It is,
So you're just not going to be here tomorrow?
yes, sir. I'm going
Just
to
do
be,
PC tomorrow?
I'm going to be in Galveston and yeah, we'll waive
You know
PC.
that you can always Zoom.
I know, but it's always hard to do that.
Okay, not a problem. What's your cost?
255-5734.
On Garcia.
Yes, sir.
Got it.
And it's a .1213 breath test. He hit a police car that was blocking an accident scene as he pulled up. No one was in the car. It was blocking the scene. That's the situation.
You want to read it real quick? Oh, we're still going to do it tomorrow.
Oh, we're still doing it tomorrow.
Tomorrow, yeah, we're just kind of like informal PC.
Thank you.
No, never.
I have to put you or just, one affidavit, but whenever you're ready.
I can come after this.
Yeah, no problem. Whenever
Okay.
you're ready.
Yeah, I'll be right there. Okay, you ready?
Oh, which one?
Oh, yes.
Yeah, go for it.
All right, got it.
So on March 15th, 2025, an officer was working a crash scene in Pasadena, Harris County, Texas. At approximately 1:15 a.m., the officer heard tires squeal in a vehicle collision a short distance away. The officer observed a vehicle had collided with a fully marked police vehicle with emergency lights activated. The officer observed the defendant to be the driver and sole occupant, and he appeared confused and had glossy eyes. The defendant exited the vehicle, and the officer observed red glossy eyes, slurred speech, uncoordinated and lethargic movement, and the odor of alcohol emitting from the defendant's person. The defendant admitted to drinking 2 beers. SFSTs were conducted 6 out of 6 on the HGN, 3 out of 8 on the walk and turn, 2 out of 4 on the one-leg stand. The DIC was read, and the defendant consented to the breath specimen, results .134 and .123.
Any pride to be honest?
No, Judge. Well, sorry.
There's someone else's criminal history. There's no DWIs on it, but there's someone else, clearly someone else's criminal history attached to his out of California.
So that's incorrect. That's not his criminal history. is what
No,
you're
there's
saying?
no way it can,
Okay.
there's like, I can show it to you. It's about every other crime other than DWI is listed from 2017 all the way to now. He's never lived in California. His name is Cesar Garcia.
Yeah, there's got to be a quintillion Cesar Garcias. But does it match up with the FBI number? I mean, because they always have an FBI number, you know?
I can show you the history if you want to see it, Judge. So you can see it's literally, like, he wouldn't be here. There's ag robberies, ag assaults, robberies, all of
I don't know. Do you see any prior DWIs?
No prior DWIs on the California history.
So, I mean, I guess do this, you know, if there's no prior DWIs, I'm not going to put an interlock on it, right? I'm going to order him no drugs, no alcohol, randoms,
Yes, sir.
randoms, that's it. But look to see if it's him or not.
Right, absolutely. I've seen this happen before.
And of course we have to.
Yeah, so
It happens.
we'll look into it.
So yeah.
because of his age, it just didn't add up.
Oh, is he on?
He's 26 and his history goes back to
Hey,
27.
I've seen people here 19 with laundry. So yeah, you're good. So just pick a date and then we'll do PC again with him. Just no drugs, no alcohol, randoms. That's it.
Thank you, Judge.
For sure. Did you need something, counsel? Oh, he's coming. We're waiting for him to come back.
Yeah, for the result.
Yeah. Okay. I'm gonna.
Thank you.
So, you were Alan Villasana. Sir? Mr. Villasana, you were charged with 2 cases. You were charged with theft. You were also charged with racing on a highway. On both of those cases, you were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The theft or the racing, which
Yeah,
was
start on the theft because
theft.
earlier one, yeah.
On January 1st, 2025, officers were dispatched to a shoplifter call at a Target in Harris County, Texas. The complainant, the loss prevention employee, called the officer regarding a theft in progress at the location and observed a Hispanic male wearing a tan hoodie and black shorts making a selection and removed the security tape from a JBL speaker box and placed other products inside the shopping cart. The complainant proceeded to keep the surveillance on the male and observe the defendant proceed to exit past all points of sale without any intent to pay for the items. The officer reviewed the surveillance and observed the complainant make contact with the defendant at the front entrance and attempted to retrieve the stolen items, and the defendant proceeded to leave the Target and enter a black Chevrolet Spark. With the assistance of a license plate reader and TLO, the officer determined the motor vehicle to be driven by the defendant and obtained a Texas driver's license, which the officer believed completely matched the Hispanic male captured on the surveillance footage. The total taken was $499.03.
On the racing, please.
Yes, Your Honor. On March 15th, 2025, the officers observed a black Toyota Camry and a silver Chrysler sedan traveling at a high rate of speed on the main lanes of the Katy Freeway. Officers attempted to catch up to the motor vehicles traveling 120 miles per hour to keep the motor vehicles in sight, but both motor vehicles were still outgaining speed. The posted speed limit was 65 miles per hour. But both the defendant and the silver Chrysler were racing in competition side by side at points, with both motor vehicles accelerating at a high rate of speed, attempting to outdistance and outgain each other. While the defendant and the Chrysler were racing, they were making evasive lane changes and failing to signal lane change, cutting off multiple motor vehicles to get around traffic, causing victims with their motor vehicles to take evasive actions to avoid collisions. The defendant's motor vehicle at one point drove on the right shoulder to pass vehicles in the right lane and was in front of the silver Chrysler. A traffic stop was initiated.
So driving on the shoulder
Yes,
to
on
get.
the shoulder. A traffic stop was initiated and the officer made contact with the defendant, who was the driver. The defendant admitted that he was racing with the other vehicle and that this was not his first time racing, but his first time arrested, and that he would have ran from the officers if he had more gas in the motor vehicle.
Mr. Villasana, I'm going to find that there's probable cause to go forward on both of your cases. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke the bond on both of your cases and I'm going to put you in jail. I'm also ordering you now not to drive. You will be signing an affidavit with me today promising me you're not going to drive. Do you understand?
How long?
While this case is open. And if I find that you do, likewise, it's not going to go well for you. Do you understand?
Yeah.
Can you print me out more affidavits, please? You're not to go to any target whatsoever as well. If I find that you pick up a third case, it's really not going to go well for you. Do you understand? I'm going to do everything in my power to protect my city at all costs. And if that means putting you in jail and making your bonds high, I'll do it in a heartbeat. Do you understand? Do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer?
I didn't have a job right now, so I can't.
Okay. Deputy Miranda's going to give you an application. I'll have you fill it out and I'll take a look at it with you. Hey, I'm not done talking to you. I'll have you take a look at I'll have you fill it out. I'll take a look at it. I'm going to have you sign a receipt with Victoria. I'm going to have you come back because I'm going to have you sign an affidavit with me today promising me you're not going to drive. And then you'll get with Fleischer for your bond conditions.
I won't be able to come back. I don't have a ride.
Figure it out. I'll get you a lawyer and we'll start talking. But I don't want any more problems. Do you understand?
No, I haven't been in problems like 5 years. This is the first time I had a case since 5.
No, please. Good morning, Mr. Alipio.
Yes.
Sir, you were charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 13th, 2025, an officer observed a blue Ford F-250 driving at a high rate of speed. The officer paced the Ford driving 79 miles per hour in a 60 mile per hour zone. The officer observed the vehicle to fail to maintain a single lane, driving over a solid dash line, and driving between two lanes with other motor vehicles in the area when the vehicle failed to maintain the single lane. A traffic stop was initiated. The officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed the defendant to have slurred speech. The defendant stated he drank one alcoholic drink prior to the traffic stop. The officer observed the defendant to be staggering while walking, using the motor vehicle for support, and the defendant to have the mild odor of alcohol upon his breath. The defendant appeared confused, and the officer had to repeat himself multiple times. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 2 out of 8 clues observed on the walk and turn. 3 out of 4 clues observed on the one-leg stand. The defendant stated he drank 2 to 3 alcoholic drinks prior to the traffic stop. The defendant was arrested. An inventory search was conducted of the defendant's vehicle, and the officer observed a warm to the touch white cup in the center console.
Alcohol while driving?
3 to 3/4 full while with the smell of an alcoholic beverage. The defendant was read the DIC and refused the breath test. A blood search warrant was signed and executed.
Mr. Alipio, I would hope that you would recognize it's elementary that you're not to have alcohol in the car while you are driving. I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. I am now also taking away your privilege to drive. You are not allowed to drive. If I find that you do, because I will have you sign an affidavit, a promise with me that you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, likewise, you will go to jail. I do not know what your immigration status is, but if you are not in this country with permission and you go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck like Chuck in custody until this case is over with, and then you get shipped off to immigration. Do you understand?
Yes.
I am sending notice to DPS that there is now a restriction on you that you are not to drive any vehicle that doesn't have an ignition interlock on it. If you were caught driving a vehicle and it does not have an ignition interlock, every officer in this state will know to arrest you and put you in jail. Do you understand?
Yes.
Your Honor, just to clarify, so he can drive so long as he has a guardian ad
No, I'm taking away, he's not allowed to drive at all.
Would you consider reinstating his ability to drive because he owns his own business?
I'm not ready yet. All I know is that he's got alcohol allegedly in the car while he's driving, and it's a second offense. Look at me, Mr. Alipio. Do not drive. Do you understand?
Yes. Yes, sir.
Because of this restriction, you will now be required to obtain a portable device that you're going to take with you everywhere you go to prove to me that you are not consuming alcohol. I don't know if you have a problem with drugs or alcohol. If you do, now is the time for you to address it. Because if I see it becomes a problem, I'm going to address it for you. And I promise you're not going to like the way that I do it. Do you understand? Yes.
Yes.
Because you have a lawyer, I will waive your appearance. That means that you don't have to waste your time coming to court, but it is your responsibility to stay in touch with Lee. If she tells me that she can't get a hold of you because you're ducking and dodging phone calls, you're playing games, you're not responding to her, likewise, I will issue a warrant for your arrest. I'm going to do everything in my power to protect my street at all costs, and I have no qualms about putting you in custody. If you don't believe me, ask Lee. She knows. For now, I will have you come up here, swear test that you're not going to drive. After that, you'll get to Victoria where we will have you sign a receipt. After that, you'll get with Felicia for your bond conditions. And after that, you'll be free to go. It's not forever, but I want to know that he truly appreciates and not just, oh, I'm sorry. I'm sorry.
Yes, Your Honor, his prior DWI was in 2003, so he had not had alcohol in a long time.
How do we know? How many times has he not been caught that we just don't know?
No.
I don't know. But all I know is he's got alcohol in the car. He has a prior DWI. So he's already on notice of what you can and can't do. I have a problem. So
Yes, Your Honor.
just proactivity goes a long way.
Yes, Your Honor.
All right. Good luck to you, Michelle.
We have one question. Did the judge's denial of a PR bond based on prior failures to appear properly comply with the Eighth Amendment's prohibition against excessive bail and the bail setting factors under Texas Code of Criminal Procedure Article 17.15?
You know, here for Mr. Flores, Adrian Flores. He's in the holdover. He's got a terroristic threat and a serious bodily injury charge.
Hey, how are you?
Harold, what would you like? What are we doing?
Just today was the day we're going to come back for the mental health evaluation, and they just sent it to me this morning. Haven't had a chance to read all of it. They did say he was competent, but I still don't think something's right with him. I talked to him.
So get a second opinion. You know, if you need money for a second evaluation, I'll give you money.
And I don't know. I mean, it might be he's competent, but just something's not correct, you know, with their thinking and reasoning when I was.
Are you able to communicate with them?
I am. Well, just for instance,
Limited fashion or something, or what?
Sorry?
In a limited fashion?
No, he can communicate. Just for instance, I was just told, well, I just want to go ahead and work it out because then I'm going to hire an attorney and we're going to get them all dismissed later. I'm like, no,
Yeah, don't worry.
if we're going to do this, we got to do it now. We have to decide we're going to trial now. And
That's I want to get out as quick as possible and then
kind of, but that was a little more than that though. Just,
to talk to him.
I mean, I guess it would be a safe thing. Just explain to him what's going on.
Do you mind bringing out Mr. Flores? Do you need a translator?
No, sir.
Adrian Flores, please.
And I think he understands now, but it just might be a misconception. Maybe jailhouse lawyer talk or not understanding his
I don't know.
cases.
Does he have his spending in the 220? This case?
No other cases pending as far as I know.
Good morning, Mr. Flores. How are you?
Good today.
Good. The reason that you are still in custody is that we gave you a PR bond and you take off. You don't come back to court. This has not happened but once. It has happened already multiple times. So that's why I can't just continue to give you PR bonds. When you do, you just take off. The only thing I need you to understand is that, you know, when you plead guilty to something, it sticks with you forever. You cannot try to plead guilty to something, get out and try to change it or do this or do that. This is when you do this, when you accept a plea bargain, it stays.
Judge, Your Honor, I'm truly sorry for what I've done, like my whole life. I just asked for another PR bond. I'll make it to court. I actually call my mom, see if I could stay with her until she drops me off at court, and whatever they say from there, if I'm guilty or not guilty, I'll plead guilty. Or if I'm innocent, I'll
Where you
plead
living
innocent.
now?
My mom stays in Tomball now.
No. Are you living on the street or are you living?
I'm homeless, but I've actually talked to my mom, and me and her actually going into a good relationship now.
Did you just get picked up?
Like mother and son. And yeah. They caught me at the airport, and
Look, I don't want you to talk about the case. The thing is that I don't want to continue to give someone a PR bond if you're just going to go to the streets. The streets are not a safe place.
I won't go back to the street. The streets aren't for me anymore, man. Like I don't want to be in the street. I don't want to be homeless anymore. And I've talked to my mom. She's doing real good, and she actually wants me to be around, pay the bills, and and own a house of my own.
Let's do this. Why don't we do a TRAS to see how we go forward? Because I don't know, and we can have the clinicians evaluate them to see how we go forward.
First,
if you want to do an independent one, I'm happy to give you money for you to do it. Or like I would suggest is just do a TRAS to see where do we go? Because I don't know, but having clinicians talk to him might be the best way to go to see how we go forward. Because the problem is, Harold, is if we just throw him out to the streets, we're throwing him out to the wolves. If he doesn't have a place to go to, or just, Whereas if we have a TRAS, we can try to get down to what the true issue is and why it keeps happening, and then we'll figure out a plan, So you just let me know whatever you want to do. I'm happy to do it.
So Judge, when we do the TRAS, we just set that up with the CLO or?
Yeah, so we'll have Shatori set it up and we'll do it. We can expedite it so it gets done within the next couple of days, so he's not just lingering.
Judge, as his competency is also good then?
Yeah, competent. Yeah, so we can get it done. And then that'll really tell us, perhaps he needs to be in mental health court. I don't know. But that's what we can get the TRAS for.
So what do you think, Judge, 2 weeks or?
No, not even a week. A week. Okay. Thanks. All right, Mr. Flores. Good morning, Mr. Lundy. Sir, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 12th, 2025, at approximately 4:45 p.m., an officer was dispatched to an FSDI call. Upon arrival, the officer spoke to the complainant, who stated he was traveling north on FM when a vehicle crashed into his vehicle. The driver then fled the scene without exchanging information. Complaining witness to the passenger stated that they were rear-ended, causing the defendant's vehicle to crash into a ditch. Defendant then approached them to check on their welfare, and once he saw they were unharmed, the defendant fled the scene on foot. The officer observed significant rear-end damage to the complainant's vehicle. The complainant provided a description of the defendant, and the officer ran the license plate and found the registered owners were Michael Lundy and Dylan Lundy. On March 13th, 2025, the officer received a call from Dylan Lundy, who wished to provide a voluntary statement regarding the incident. The defendant admitted to crashing into the complainant's vehicle and to fleeing on foot because he believed he had an open warrant for failure to appear for a window tint violation. The complainant positively identified the defendant by photograph. The estimated cost to repair was over $200, as the complainant believed their vehicle was totaled.
Okay. Can you run his license, please? And does he have any open cases anywhere? If you can run an NCIC.
His driver's license is eligible, and I normally don't take note of Class C violations.
No, I don't care about Class C.
Right.
No, I don't care.
He does not have any open cases at the moment.
Got it. All right, Mr. Lundy, I'm going to find there's sufficient probable cause to go forward with your case. The only condition I'm placing on you now is you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you may not drive. You understand?
Yes, sir.
Okay, I will waive your appearance because you have a lawyer. Just stay in contact with Will. He'll tell you if and when you have to come back to court. I'll have you sign a receipt, Victoria, while you take a seat while we get your conditions. You'll sign it and then you'll be free to go.
Thank you, Judge.
Don't pick up any new case.
Yes, sir.
Is that pre-trial bond conditions?
Estate's conditions.
Okay.
Okay,
Next is
so-
on page 12. Howard, come on up.
Can you file those, please? Good morning, Mr. Phillips.
Your Honor.
Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
On March 12th, 2025, at approximately 9:25 a.m., an officer was conducting a stationary traffic enforcement on a public roadway of the 7,000th block of IH 610 southbound in Harris County, Texas. The officer observed a red Ford pickup truck traveling at a high rate of speed with heavy traffic the posted limit was 60 miles per hour. The officer witnessed the pickup truck bypassing other motor vehicles, weaving in and out of traffic at high speeds and coming dangerously close to other motor vehicles, with other drivers having to brake to avoid collisions as the Ford cut in front of them recklessly. The officer witnessed the pickup make multiple unsafe lane changes. A traffic stop was initiated. The officer reached speeds up to 110 miles per hour to catch up with the truck, but the pickup continued to distance itself from the patrol vehicle. The officer made contact with the defendant, driver, and sole occupant. The defendant admitted, "I know I was driving like an idiot. I just got off work." The defendant acknowledged he was aware that he could have caused an accident and hurt someone.
Mr. Phillips, I'm going to find that there's sufficient probable cause to go forward with the case. If I find that you drive like this again, it's really not going to go well for you. Do you understand?
Yes, sir.
I will protect my street at all costs. If that means putting you in jail with a $500,000 bond, I'm going to do it in a second. Do you understand?
Yes, sir.
Anymore, I will also take your privilege to drive away from you as well. Can you look to see if he has a license?
Yes, his driver's license is eligible, Your Honor.
You are not allowed to drive unless you have valid liability insurance in your name, and that is also now a condition of your bond. No reckless driving, maniacally driving, donuts, street takeovers, anything of this nature. Do you understand?
Yes, Your Honor.
You will sign conditions to this, and after that, you'll be free to go. You have a lawyer. I will waive your appearance. Just keep my street safe, man. Every day we have people dying. It's not fair. Do you understand?
Yes, Your Honor.
Okay, come on.
Thank you, Judge.
Right this way.
You are Mr. Albardon? Sir, you're charged with terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thomas
On
Flores?
March 12th, 2025, an officer responded to a weapons disturbance call at a residence in Katy, Harris County, Texas. Upon arrival, the officer met with the witness, who stated the defendant, her brother, and the complainant, her sister, were inside the residence and were involved in a verbal disturbance. The witness believed the defendant walked upstairs to retrieve a firearm during the altercation, which caused her to walk out of the residence and call 911. The witness, the complainant, and the defendant were eating at the dinner table, and the defendant told the complainant that he will shoot the complainant and the complainant will need to leave the residence. The complainant stated that she lives at the residence with the defendant. The complainant stated the defendant got into a verbal altercation with their father, and the defendant stated that he was the man of the house. The defendant attempted to slap the complainant in her face, and the complainant moved her head back, causing her hijab to fall off her head. The defendant told the complainant he would grab a gun, hold her down, and shoot her. The defendant would see that the complainant would not be in the residence. The complainant stated she felt in fear when the defendant threatened to shoot her.
Mr. Albardon, I'm going to find that there's sufficient probable cause to go forward with the case. A protective order has been issued in this case that identifies Ms. Lubna as a protected individual. Get to know this protective order, because if you do something to violate it, the state can and will file a violation of a protective order against you. And it's one of the worst cases that you can pick up. Do you understand? One of the things is this comes with a residential restriction that you're not allowed within 200 feet of the Park Fair Courthouse. Do you understand? If you go back to this place, it's not going to go well for you. Do you understand? How old are you, sir? How much? 33. Do you work? Do you have the ability to hire a lawyer? So what I'll do is I'll have you fill out an application for me. I need to know whether you can qualify for a court-appointed lawyer. Any allegation of alcohol or McKenzie? Any alcohol or any dope, anything like
No
that?
allegations of alcohol.
Okay. So for now, what I'm going to do is I'm also ordering you not to have any contact with this person and not to be in possession of weapons. Do you understand? I'll provide you a lawyer today and we can talk about how we go forward, but just be careful. I don't want to have to put you in jail. Do you understand? Okay. Do you mind giving me an application? Deputy Miranda's going to give you an application. I'll have you sign a reset with Victoria, and then we'll have you take a seat in the jury box. Good morning, Ms. Burse.
Sorry, I lost my voice.
Burse, that's what's right?
Yes.
Okay, ma'am, you're charged with criminal mischief. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. Just hang tight and we'll, okay?
On March 13th, 2025, an officer responded to a criminal mischief call at a residence in Harris County, Texas. The officer made contact with the complainant and the witness who directed the officer to the scene. The complainant stated the defendant came to the location, broke his motor vehicle window, and recorded the incident on his phone for the officers to see. The complainant stated the defendant left the location in a black Kia that had the location on. The complainant stated the defendant was on Rust Creek Drive at an apartment. He could point to her apartment. The cost of the damage to the motor vehicle was approximately $500. The officer reviewed the video and observed the defendant striking the front passenger window, causing the window to shatter, then leaving the location. The officer observed a brick inside the motor vehicle with glass shards inside the front passenger seat floorboard and outside the motor vehicle. The complainant was positively identified by her Texas ID prior to driving to her location per GPS. The officers followed behind, and the complainant pointed at the apartment as the defendant was standing right outside of it. The officer made contact with the defendant, who was wearing the same outfit in the video, and the defendant admitted to breaking the complainant's window.
Got it. Do you have the rip done? I'm assuming he just complaining doesn't want to have contact with her?
We do not have, we have.
Not yet? Okay. Ms. Burse, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with this person. Do you understand?
Yes, Your Honor.
I don't care what's going on in your life. Don't have any contact with this person. I'm also ordering you not to be in possession of your weapons as well. If I find that you're a danger to my community, it's not going to go well for you. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yeah.
Are you sure?
Yes.
Do you want to apply for a court-appointed lawyer?
If I really don't need one, then
You need a lawyer.
Okay, then
You're facing 6 months in jail,
Then yes.
$2,000 fine, plus it could go on your record, and it's disastrous when it goes on your record.
yes.
It's a good idea. Do you mind giving her an application? So I'm going to have you fill out the application. I'll have you take a seat in the jury box. We'll get your bond conditions. Do not leave until you sign them. And then I'll have you talk to a lawyer here momentarily. All right. Good morning, Mr. Miller. Sir, you're charged with harassing communication. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The complainant informed the officer that on November 9th, 2022, in Harris County, Texas, the defendant was sending the complainant harassing text messages to the complainant. The complainant and the defendant had been in an on and off relationship and had recently ended it. The defendant would call and text apologies that he would love her. The complainant stated eventually that the defendant started conveying messages that were angry in context. The complainant blocked him in response, and then she began receiving calls and texts from unknown numbers. The complainant even asked the defendant's mother to tell him to stop calling her. The complainant stated that the night that she received calls and that night she received calls and texts from the defendant with him threatening to call Child Protective Services. The complainant and the defendant were using an app and calling and text. The defendant was using an app and calling and texting from different phone numbers, and he sent multiple phone numbers and different text messages that are outlined in the officer's report.
Gary Phillips.
Are we talking like tons of text and stuff? How many are we
Yes,
talking?
Tons of texts from different phone numbers after the complainant had repeatedly told him to stop.
Okay, I see. I'm looking at dozens and dozens. Okay. All right, Mr. Miller, I'm going to find there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person. I don't care what medium it is. I don't care if it's a smoke signal. I don't care if it's with Snapchat, WhatsApp, social media. If I find that you do, I will revoke your bond, put you in jail. Do you understand? No means no. Just, you don't have children with this person. Move on. There's 10,000 other fish in the sea. It's not worth it sitting in a 6x9 because of one person, right? All right. I'm also ordering you as a condition of your bond not to be in possession of weapons as well. Do you have the ability to hire a lawyer?
Yes.
Okay. So what we'll do is we'll give you time to hire a lawyer. I'll have you sign a reset with Victoria. We'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Please. Good morning, Mr. Lennon. Sir, you're charged with illegal dumping. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 23rd, 2025, a witness stated that he saw the defendant dump a sofa on a 22-800 block of Fair Lake Lane on Tuesday, January 21st. The witness stated that he was cooking and looked out of his kitchen and saw a truck and the defendant come out to dump it. And the witness took a photo of the defendant's license plate and of the defendant. The witness told the defendant that you can't dump trash there, and the defendant looked up at the sofa he already dumped and left. The witness stated he was concerned the defendant was going to dump the sofa at a nearby location, so the witness drove to the main roadway near his house and observed the sofa had been dumped at an abandoned car wash located at 11440 FM 1960 in Huffman, Texas, which is not an approved dump site by the Texas Commission on Environmental Quality. The witness is positive that the sofa is the same brown sofa that the defendant dumped near his house previously.
But he didn't see it.
No, Your Honor, but he did it was the same sofa, and he did follow, and then at that point, the sofa was still on the side of the road. Yeah. The witness stated he was cooking, looked out his kitchen.
I know that he sees it. So he doesn't dump it that first time. He goes to a location, he's about to dump it, but he doesn't, he takes off.
Sir, I would just request, this is not with us, this is with environmental. I would just request we hold off on PC ratings until the prosecutor hears the case.
Okay, I mean, I'm willing to hold it, but, you know.
I get it. I just want to make sure the prosecutor.
Ms. Runyon, just take a seat in the jury box, please.
Morning, Judge. I have a gentleman by the name of Cayuba Thomas who is with us today. He has a warrant. It's kind of questionable, but nonetheless, he does. And he wanted to turn himself in.
Okay.
I wanted to see if depending on probable cause, if you did set a bond, whether you might consider a PR bond because his medical condition.
Don't worry about it.
Gotcha. Would you like him brought up, Judge?
Please.
Okay. Mr. Thomas?
Good morning, sir. Good morning. Sir, you were charged with terroristic threat. You're facing up to 6 months in jail and a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be.
This is a misdemeanor OWPD, operating with the presence of drugs. That means the prosecution doesn't necessarily have to prove visible impairment. Just the presence of THC in the system can be enough under certain statutes.
Appointed to you, sir. Okay.
On February 6, 2025, the officers interviewed the complainant, who stated that on January 18th, 2025, the defendant came into the 5-minute oil change located at 747 Barry Ashford Road in Harris County, Texas, to have maintenance performed on his vehicle. The defendant let the complainant perform a cabin check on his vehicle, so the complainant got inside the vehicle. The complainant and the defendant then exchanged a verbal exchange because the defendant was upset that the complainant was inside the vehicle. The complainant's manager interviewed and attempted to de-escalate the situation, and the defendant told the complainant's manager, "I'm going to come back here, you better correct him before I come back here. I'm going to come back here and I'm going to finish him off with a gun. I will fucking come shoot you all. I will do a drive-by." The complainant confronted the defendant and told him that he was not welcome back. The next day, the defendant was captured on surveillance footage at a location speaking with the complainant's coworker, who informed the defendant that the complainant was not at the location. The defendant went into his armrest and the witness stated that the defendant went into his armrest and he pulled out his gun while uttering the words, "Because of what happened yesterday, I should have shot his ass," referring to the complainant. The defendant stated, "I'm going to come every day until I see him."
And Judge, that's simply not true. In fact, I have his.
Remember, this is a probable cause.
I understand.
Start getting into more stuff. I mean, my only concern is, was there a terroristic threat, right?
Exactly.
And I don't know, it looks like there were potential multiple threats. So which one is in the charging instrument?
I think the one alleged to have occurred
on the actual day in question when everything.
I can look and double check.
Because what I have, Judge, is just a receipt from when he paid. And because of the way he was treated, they gave him a $20 discount. It shows on the receipt as well. So, he had told them, don't upsell me. He comes around the corner and the guy's in his car. So that's why they gave him the discount on this.
But I mean.
Even so, Your Honor, a discount was a discount when it happened.
No, I understand.
And just to clarify, it is the first threat on
First
January
threat.
18th.
Yeah, I mean,
It is what it is. I understand.
So, Mr. Thomas, I'm going to find that there's sufficient probable cause to go forward with the case. The only thing I'm going to ask you to do is don't have contact with the complaining witness, don't be in possession of weapons, and don't go back to the 5-minute,
5-minute oil change.
Yes,
the
sir.
5-minute oil change. That's all I'm asking you to do, really. Just don't have weapons and don't go back, okay? That's it. As long as you can.
Ask for them to contact with the complaint.
Of course.
We'll fix it. We'll get it. Alrighty. Anything further, Judge?
We have to do bond.
Oh, I'm sorry.
Um, Might bring me out of PSM. Sorry.
It's already set at $100.
Oh, it is? Okay, so I don't need to, all right. So, Mr. Thomas, I'm going to grant you a PR bond today. You have a bond set at $100. I'm going to grant you a PR bond. All I'm asking you to do is just don't pick up any new cases. Just be nice. It's not hard. You've got a great lawyer here. Listen to him. He'll take care of you. I'll waive your appearance because you have a lawyer. You don't even have to come back. Just stay out of trouble and just, that's it.
Okay, thank you very much.
So I don't let him, I need you to sign a bunch of paperwork. We have bond conditions that we're going to create. I need you to sign them. Do not leave until you sign our bond conditions. You'll have to meet with police for your PR bond. And after that, you'll be free to go. Okay? All right.
All right, thank you very much, Judge.
And then, Judge Powell, do you
Yes, sir.
attorney record, please?
Yes, sir,
We
certainly.
have him over there in the tower.
Okay, thank you.
Judge, I need the.
Sir, you were charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you have done. You need to understand that this DWI will go on your record. It will be there for the rest of your life. It's even there after you die. This is important because if you get pulled over in a car, an officer comes up to your window, they see that you have a prior DWI and they smell alcohol on you or they smell anything funky, it's probably not going to go well for you. What we're doing today, the proverbial slap on the wrist, will not happen again. From now on, it's a minimum of 90 days in jail. Do you understand?
Yes, sir.
You're giving up the right to trial. Hell witnesses to testify on your behalf. Confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you can never change this. Do you understand?
Yes, sir.
You still want to do this?
Yes.
Is it true or untrue that you had a
no es verdad
5 or above?
tenía un 2,5 más? ¿Verdad o no verdad? ¿Verdad o no verdad?
Sí.
¿Verdad o no verdad?
True.
Answer. All right, sir, I'm going to find you guilty. I'm going to sentence you to 3 days in jail, give you credit for the 1 day that you've done. I am going to suspend your license for 90 days.
Yes.
Do not drive until you get a license. And I'm going to tell you now, I will waive the $4,500 surcharge that normally applies in this type of case because we all make mistakes. But if you continue to make mistakes where you endanger other people's lives, a second DWI not only is a minimum of 90 days, but it's a $6,000 surcharge. Do you understand?
¿Lo entiende?
Yes, sir. All right, good luck.
Thank you, Judge. Have a excuse.
Thank you. Hey, you ready? Come on.
Yeah, I just want to touch on bond conditions for Mr. Bardian.
Okay.
B-A-R-D-A-N.
So you got appointed Mr. Albardan?
Yeah.
Great. Okay.
He has a residency restriction to stay away from his father's house. That's where him and his siblings live. And I want to approach you about lifting that up to no harmful or offensive contact.
And I'm okay. So he's Mr. Albardan. Come on up. Your lawyer wants me to change the conditions so that you can go back to the house. But I want you to understand that if you have a very tumultuous relationship with these people where you're always butting heads with them, it's not going to go well. I don't want you to have any threatening or harassing contact with them. What is threatening or harassing doesn't matter what you think. It is what they perceive. So if you go like this, is that threatening or harassing? It most certainly is. And they can land you back in jail. Do you understand? So if you cannot be nice and if you cannot get along with brother and sister or dad, be very careful. Because if I get wind that it's not going well and that you're threatening or you're putting anyone in danger or you have a weapon, I will put you in custody. You understand? Okay. All right. I'm done.
Thank you, Judge. I'm excused.
The only, Mr. Albardan, The only thing I'm taking off of the protective order is the residential restriction. Everything else in the protective order stays. So if you threaten them, if you harass them, they can charge a new case on you. Do you understand?
Yes, ma'am.
Okay. All right.
I will convey that.
And if you can file, no, now we need,
State bond condition.
yeah. So, Mr. Reedy, we need new bond conditions. He can't leave just yet. So we need him to sign no threatening or harassment.
Right there, not to leave.
Okay. Stay.
Last name is Bledsoe. Bledsoe.
Okay. You want to bring him on? Are we going on the evading and the terrorist act that's going to be dismissed? Good morning, Mr. Bledsoe. You were charged with evading arrest and detention. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're going to dismiss your terroristic threat in exchange for your plea on the evading arrest. You need to understand that evading is an enhanceable offense. This is going on your record today. It'll be there forever. From now on, if you ever run from the cops again, you'll be facing a felony charge, years instead of days. Do you understand?
Yes, sir.
Not only that, it's a minimum now of 90 days for any new cases that you pick up in here. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it stays on your record forever. Is this what you want to do?
Yes, sir.
How do you plead to the offense, sir? Guilty or not guilty?
Good, sir.
I'm going to find you guilty. I'll send it to you with agreement. If it's enhanced, it'll be abandoned. Good luck, sir.
Thank you, Jenna.
Anna, we have court orders for a reason. And when you don't follow court orders, bad things happen. Do you understand?
Yes.
You were ordered to get an interlock and you didn't get it, or a portable device and you didn't get it. That's unacceptable. When you don't, there are serious, serious consequences. The only thing I'm asking you to do, don't endanger my streets. Don't kill someone on the road. Do you understand?
Yes, sir.
I'm going to find no probable cause in your case now. But if you come back with a new case and you don't follow court orders, it's really not going to go well for you. Do you understand?
Yes, sir.
All right. Good luck.
Thank you, Judge.
I think that we are, you know,
Sorry.
it's okay. No, and I think you're right. You know, we were going through the lawsuit and, 2017, the county came into an agreement where we're basically holding it to a higher standard, so to speak. I mean, theoretically, could I weasel out of it? Yes, but I don't want to, I want to stick with the agreement that the county came to with the district attorney's office,
So, not saying this, I'm just for curiosity.
The DIMS has to state an offense, right? It has to have all the elements of the offense to go forward. The reason, I would presume that offense reports don't is because they're continually just updated and they're amended and they supplement it. So it would be unreasonable to have an officer every single time they swear to over and over and over and over, because shit, you might get like 15 supplements.
And here's my question for the court, and I'm not saying we do this in this case, I'm just saying for cases going forward. To me then, does that then behoove, does that say we can't take it to grand jury?
You can, of course you can.
So
just because I find no probable cause on something, if you want to go indict it, go do it.
Right. Okay.
Absolutely. There's nothing barring you from doing that. Right? Because if a grand jury finds something different, then that's on them. As far as me, I'm going to just hold to the standard that we agreed with the county in the lawsuit.
Yeah, and this is for my own.
And you're not going to hurt my feelings if you go to a grand jury.
I know. I just, so we wouldn't be held to that same standard.
You need to do what you think is right.
Okay.
Like I'm going to do it, and like she's doing it. The problem is that whoever had the apps, they didn't dive into it and really look into it as Anna did. Not everybody is.
This is required
Which is good.
Thank you.
God love you.
Good morning.
Is it? All conditions will continue. You are not to use. Do you understand?
Yes, sir.
I will test you again in about 45 days. If you test positive again, it's not going to go well for you. I'm not asking much. Do you understand?
Yes, sir.
Okay. All right.
And
That's
we are
it.
doing, we're working on a PTI with a,
The quicker you get it done,
that's what I'm saying,
the quicker it is for you.
they do want to test as well as a condition, so, once we test them again, then we get submitted.
You hold the keys to the jail cell. No one else. Do you understand?
Yes, Your Honor.
Thank you, Your Honor.
Yes, ma'am.
Thank you.
Yes, Your Honor.
I'm going to find that there's no probable cause to go forward in your case. Aren't our streets dirty enough?
Yes.
Don't say anything. Just please,
Understand.
keep it nice.
Yes, sir.
All right, please.
Thank you.
Lee.
Hey, Judge, may I approach?
So you got something interesting?
Oh, we were going over, on this case, we were talking about, if a private citizen, takes somebody's car key and seizes somebody and holds them there till the officers show up, is it, allowable or not? And so,
Well, it would have to be a felony or a breach of the peace, right?
right, it would have to be one of those, because otherwise it could, I was telling them it could be argued it's fruit of the poisonous tree, it's an unlawful seizure. And so if it's a government action, it's.
I thought you were getting more toward a kidnapping.
Oh, no, to like say it's an unlawful seizure, like, there's, we were comparing versus, it's not because it's a private actor, but I'm saying, hey, even if it is a private actor, if it effectuates what a cop would be doing, it would fall under the same tenets of, unlawful search and seizure, and so.
Certainly interesting.
Yeah, I don't think we're gonna get there, though. I don't think we're gonna get there on this one. I don't think we're gonna get there on this one. It's,
Theory's wonderful,
So,
Yeah.
Mr. Lázaro Echemedia.
It's old.
Yeah.
What do you want to do?
So we're set to plea or set it for trial today.
Correct.
I see some issues in the case. I've talked to my client. He is interested in possibly doing something different, but he is,
what other?
we need an immigration concept, well, possibly time served. But the thing is, the holdup is, I need an immigration consult.
But that should have been done beforehand. Today we're set plea or trial. This is not.
Right, and the only thing is,
we're now 215 days.
the thing is, I was only appointed like a month ago. I saw all these issues over the weekend. And so talking to him, see if he wanted to go to trial, he's like, hey, hold on, let's get an immigration consult, see how it's going to affect me. So
Okay, so I guess I'll give him till Monday.
the only thing with that is, Judge, this consult goes through the MAC. It's Miss Julie Pash. Today is Thursday. She's been getting on me about how backed up she is lately.
It's 215 days old. It should have happened a long time ago.
Right.
You can't just, it's on him. It's not on you. It's on him.
Yeah, I'll be straight with you, Judge. I don't know why I was only appointed like a month ago. I don't know if he was missing or something.
Correct. He's been AWOL for all that. So it's not, I'll give you a week, but that's it.
Okay, I'll let her know. I'll let her know, and hopefully she gets it done. Thank you, Judge. All right. Okay, cool. Thank you.
By the end of the docket, does the judge's repeated emphasis on community protection reflect permissible judicial discretion, or could it risk appearing inconsistent with the Sixth Amendment requirement of an impartial tribunal?
See, Nathan, this is not my first bond violation with you. In fact, this is our third, and I don't know what we need to do to get your attention, but now I have to take you into custody again. She goes with you?
Let's go.
I'll have them get it. I'm sorry, Nathan, but it's the third time. I can't continue to do it.
Okay, Judge.
So, she'll probably roll up on tomorrow's docket, and then we can revisit it, like everything again, I guess tomorrow.
That sounds good, Judge.
Okay.
We'll be there.
Thanks, Nathan.
All right.
Judge, what's been the flag amount?
15,003. Hey, are you ready?
Good morning, Judge.
Hi, please.
Of
course. It's been a while. How are you? Good to see you.
You too,
I'm
Judge.
so sorry. There's so much drama up there, It's just too much.
It is, but
Down here, it's,
where they put me is where I go.
I get it.
I'm here on Miss Gutierrez, Sandra Gutierrez.
Come up, Ms. Gutierrez. Either you have a problem or you just don't care about court orders. It's one or the other. If you have a problem, I'm going to address it for you. And I promise you, you're not going to like the way that I do it. Do you understand? I'm now going to put an ankle monitor on you. And if I ever find that you test positive again for anything, and I don't give a rat's behind what it is, you will stay with me. And if it becomes an extreme case, I can have a hearing to hold you in contempt, slap you with 180 days, probate it for 2 years, and put you in a lockdown rehab facility. Do you understand? if that's what it's going to take. I'm amending the conditions now to put a scram on her ankle. I hope, above all else in this short life, you are not driving. Because if it comes to my attention that you are in violation of this affidavit, it's really not going to go well for you. You understand?
Yes.
Okay? All right?
Your Honor, we do have an offer, and we want to run it by you to see if it was something that you'd take. It is a jail offer.
So, Your Honor, it was, yeah, and this was I didn't see it, but yes, it was a minimum of 30. I think we just didn't realize she had 10 days credit, so it wouldn't be a time.
How does she have 10 days credit?
I didn't remember, so that's
That's what she did let me know. She has about 10 days credit. So we can verify.
254, 5,000. 5,005. I don't know.
It's just
Sandra Gutierrez,
she
has 1 day.
She has 1 day credit.
1 day. Where'd you get 10 days?
1 day.
That's
well,
okay.
I was in jail so I was on probation before when I caught this new charge. I was actually did a 5-year probation, and I was supposed to sign my papers that day that I was, I guess, exited out of jail, the day that I left jail. And it was like a week before, so yeah.
Please.
I'm not sure.
Just, you guys talk it over. I don't want you to say something that really hurts your case, you know. So it's probably better that you just talk with each other and figure out what you guys, we only have 1 day credit here. That's all we have. If you want to, I'm happy to do it.
That's good, Judge.
If you guys want to do it.
The 1 day, Judge?
Well, she has 1 day credit. I'm not going to give her more than she's entitled to.
I understand.
You know, I can only give you what you're entitled to,
Yes,
right?
Judge.
What you have here. So if you want to do that, you have my blessing. It's up to you guys. You let me know. But as of today, if she leaves here, she gets an ankle monitor. Plus, and then if you test positive again, it's not going to go well for you. Okay?
Sounds good. Judge,
You let me know. Yes, ma'am.
does she have to go back in here, Judge?
No, but she's got to meet with pre-charge.
Yes. On Ms. Sandra, Judge?
Yes.
We have a new offer, probation officer, 15-month offer with a TRAS. Whatever the TRAS states that she should do, she'll do it.
Okay, I'm okay with that.
Sounds good?
Absolutely.
Sounds good, Judge. Thank you. We'll write it up.
Here's the thing, though. She couldn't even make a felony probation. How's she going to make this one?
She didn't make felony probation.
Did she make it or did she get adjudicated?
She completed it, 5 years.
Tell her that if she tests positive, I will put her in a treatment facility, though, so she knows.
Yes, Judge.
Warrant is fair warrant.
Yes, Judge. And she,
Absolutely.
yes, Judge. I'll let her know.
Fam, on which one? Ms. Gutierrez, you're charged with driving while intoxicated. It's a second, am I right?
Yes, Judge.
What happens the next time? If you ever pick up another DWI, what's going to happen?
It'll be a felony.
2 to 10 in the penitentiary. Any prior pen trips?
Yes, Judge.
How many?
Just one.
You could be potentially a 15 to life case next time you pick up a DWI. 15 to life, minimum. With your record, just mere smell will be enough. So if I were you, if you want to get lit, wonderful. Just don't get into a car. Find another way. Take an Uber. 30 to 50 bucks will get you wherever you want to go in this city. Don't matter where you want to go. Anywhere. Do you understand? It's not hard. One button. All you need to do is literally push one button. Car waiting for you, wherever you want to. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, there's no turning back. Do you understand? This will go on your record. It's going to be there for the rest of your life. Now, is it being reduced to a first?
Yes, Judge.
Okay. There is a surcharge that you will be required to pay in this case. You will be required to pay a $3,000 surcharge. And if you don't pay it, every $100 you will sit 1 day in jail. Do you understand? It's a second. I'm not waiving it. And it's being reduced to a first. You were lucky because a second, it's a $6,000 surcharge that if you don't pay 1 day, every $100 you owe. So you will be required to pay this fee. You will also be required to pay the court costs as well. You have entered into an agreement where they're offering you 180 days in jail to be probated for 15 months. As part of the agreement, you will do a repeat offender DWI education class, 1 victim impact panel. You will do a TRAS to see what other conditions you may need. If they assess other conditions, you must fulfill them. They may do inpatient, intensive outpatient treatment. They may do just supportive outpatient treatment. They may do inpatient treatment. I don't know what they're going to do. but you must fulfill whatever they say. Do you understand?
Yes.
No drugs, no alcohol, guardian interlock. But since you don't have the ability to drive, you must get a portable device. 25 hours of community service. Do you have any children? Okay, get rid of the community service. I'd rather do a parenting class. $100 one-time donation to Mothers Against Drunk Driving. If you need extra time to pay, we will give it to you. All you have to do is ask. I'm telling you now, there's 3 possible things that could make this thing really go sideways. The first is if you drink. If you consume, a warrant will be issued. They will file a motion to revoke your probation. We will have a hearing here. If they prove it to me that you're consuming, it's very well possible that we put you into inpatient treatment. The other thing that the worst possible thing you could do is drive. If you drive without a Texas driver license and a liability insurance, likewise, they will issue a motion to revoke. The other thing is take off. If you abscond and you take off, it's an instant warrant. If you ever have an issue, you can come talk to us. We can work it out. There's never nothing that can be solved. Everything can be solved in this life, one way or the other. Those are the 3 things that are all hangups. Do you understand?
Sure.
So cut her fees. How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
Is there an accident in this case? No? Okay. All right, ma'am. Best of luck to you. We'll have you meet with Shori.
Thank you, Judge. Maybe excuse. Thank you, Judge. Good to see you again.
Judge, I have Dennis Fisher, and this one's getting old, but he's sent me a bunch of character letters that I need to compile into a packet. And so can I get 2 weeks on that? I'm hoping they'll approve him for PTI. They had previously offered him time served.
369.
I know, Judge. Could we get 2 weeks and then we'll just either see if they'll approve him for PTI or set it for trial, plea or trial?
Have everything?
Judge, he sent me the letters yet. He sent them yesterday, so I have to compile them into a packet.
I'll give you a week.
Okay, 1 week.
360.
Then I'll compile them in a packet today and just send them so we can at least get a response on that. You want my approach on a different one? Yeah. Judge, I have Moses Garza. I don't know if you want to talk to him. He's kind of unsure. I'm guessing we're just gonna have to set it for trial because he's.
No. We've literally set it to consider since December. Mr. Garza.
I think he's in the hallway. I can go get him, Judge.
Please. You have had since December to consider what to do. It is now time to consider now what you want to do with this case. Today is the plea deadline. You must either accept the plea bargain agreement or we will set your case for trial. If I set your case for trial, that's okay, but I'm not going to take anything else. I'm not here to play games. That's it. You're out of time. It's 190 days old. I will have you talk with your lawyer. You consider what you want to do, but today's the day.
Yes, Judge.
Okay.
Want my approach?
Yeah.
Judges, I don't know if Jorge Gomez ever checked in. He picked up a new case.
Yeah, I know. We were going to end up revoking it, right? Because he didn't show up today. And he picked up a new case. He had BVR.
I haven't been able to get him.
Okay. Okay.
I did text him, Judge.
Garza, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you have done. You need to understand that this charge is going to go on your record. It's going to be there for the rest of your life. You can never take it off. You ever get pulled over again, an officer is going to see this. If they smell anything funky, if they smell alcohol, if they smell marijuana, it's not going to go well for you. It's probably not going to go well for you. Don't give them the ammunition. Don't really. All you have to do is one button on your phone. A car will take you wherever you want to go. $40. You understand?
I understand.
Right. It's not hard. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, and give up the right to appeal, like I said. So that's why it stays on your record. Is this what you want to do?
I'm gonna have to plead, plead guilty.
Is this what you want to do?
Yes, Your Honor, it's best.
Your other option is trial.
This is the only best option right now. In trial, I would need better representation, and you being a defense attorney, you know how this is gonna go, and it's not gonna work out. And I'm not in a financial step. I'm sorry, I'm not in a financial standpoint for trial. So
our lawyer, if you want,
yeah.
You need to understand. I'm not going to take this plea if you don't think I'm guilty. We don't play games here, right? You need to understand that he's got a lot of stuff going on in his life too. He's got hundreds of cases, right? So the evidence is out there. It is what it is. Have you been able to see the evidence?
I have, and it's not good, but it's not bad
Don't
either.
talk about the facts of the case.
Well, I'm just saying, if you've seen what's out there, I don't know. I have not seen it, but juries aren't dumb.
Yeah.
They know what drunk people look like. They know what intoxicated people. Drunk doesn't have to be falling down stupid where you pissed all over yourself. And no, it doesn't have to be like that. You understand?
I understand.
Because this is a lifetime decision that you make today. Once you do this, there's no turning back. So you need to be fully aware because like I said, there's no more proverbial slaps on the wrist from now on. It's a minimum of 30 days in jail for any new cases that you pick up here. So if you want to do it, we can. If you don't, we can set you for trial. Did you apply for PTI or no?
Judge, we talked a lot about PTI and it was an income issue. He just doesn't think he can afford PTI, but we've had many conversations about it.
That's something you're going to pay for it one way or the other. You know, DPS is going to start charging you for this thing, right? Your insurance is going to skyrocket. Insurance now is crazy as it is. So you're going to pay for it one way or the other. The option for PTI is if you're granted entry into it and you complete it, the case gets dismissed.
Not a financial standpoint, Jaden. Like, I've been over my financials and I don't want to be in a bigger hole than what I'm already in.
You don't want a trial?
I'm waiving the right to a trial.
Okay. All right. How do you plead to the case? Guilty or not guilty?
Guilty, Your Honor.
I'll find you guilty. I'm going to send you to the agreement. The only thing, just don't pick up another one. If you think that this was bad, wait till you get a second DWI. Wait till you get it only gets worse. Now, he's asking me to waive the fee for you, which is a $3,500 fee. I'm going to do it now, but you pick up a second DWI, it's a $6,000 fee, not to mention the minimum of 30 days in jail. So get a clue. It's not hard. You understand? All right, best of luck, man.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Just be safe. It's not hard. Good morning, sir. Good morning. Sir, you are charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 17th, 2025, an officer was dispatched to a call for service at the 400th block of West Gray Street, Houston, Harris County, Texas. Upon arrival, the officer observed the defendant sitting inside his vehicle. The officer made contact with the defendant and observed the defendant to have bloodshot eyes, unsteady balance, and was confused. The defendant stated he didn't have anything to drink. A Houston Fire Department employee, the wheel witness, stated the defendant was asleep in the driver's side of the vehicle with his foot on the brake and the vehicle in drive. The wheel witness stated he had a hard time waking up the defendant. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 5 out of 8 clues observed on the walk-in turn. 3 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were 0.179 and 0.175.
Where was he? Was he in the middle of the road?
It sounds like,
The-
yeah, I don't. So it says that he was sitting inside his vehicle on the 400th block of West Gray Street, which is accessible to the public. On a public road.
Don't, please. I have no idea what that is, where it is. Is he in the middle of the road? Is he in a parking lot? Is it Domino's Pizza? I mean,
It says it's on a public street. It says, well, more specifically, it says 400 block of West Gray Street is a public street.
I mean, I need more information. I mean, does it say he's on a street there, or are you assuming?
No, I'm not assuming. I'm saying what it says is that the 400th block of West Gray Street is a public street. It doesn't say specifically.
Doesn't ask him if he's driving, none of that in there? I mean, really?
Yeah, he did have the vehicle in drive with his foot on the brake and was unconscious. But in regards to the location aspect of it, there's nothing further stated on that.
Yeah, I'm sorry. I'm going to find no probable cause. I can't just go forward with assumptions here, you know? Mr. Cleary, be safe, man. You know, we have every single day. Look, this weekend, how many people died on the road here in Harris County? You know, really, be smart.
Thank you.
You know, you have but one life. Don't do something where you either ruin your life or more importantly, ruin someone else's life. Okay?
I appreciate it.
Please take a seat, sir. I'm going to find no probable cause.
All right, Judge, next is page 4. Door, Adam.
Mr. Dory, you're charged with assault with a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
Officer was dispatched to a disturbance. The complainant and the defendant are in a dating relationship. The complainant stated the defendant shoved her multiple times with his elbow and also grabbed her arm, causing pain. The officer observed the complainant to have a scratch on her chin, scratches on her arm, and a large purple bruise on her right arm.
Know that he hit her? Do we know?
So the complainant stated the defendant shoved her multiple times with his elbow and also grabbed her arm, causing pain.
All right, Mr. Dorn, we're going to find that there's sufficient probable cause to go forward with your case. This case is 1,139 days old. If you take off again, I'm going to make the bond so high, you'll have hair falling out. Do you understand?
Yes, sir.
As it stands now, I'm going to put an ankle monitor on you so I know where you are at all times. You will have a GPS monitor. I am now also issuing a protective order that you're not to have any contact with this person whatsoever. Ms. Ray Perez is now a protected individual. You cannot commit family violence or an assault against this person. Commit and act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, be in possession of a weapon, or go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
If you violate this protective order, the state can and will file a violation protective order. It's one of the worst cases you can pick up. Do you have a lawyer today?
No, sir.
What are you doing about that?
Need to find one.
Okay, we will give you time. I'm telling you now, I'm fast tracking this to trial. In 30 days, is discovery complete?
Discovery, it looks like we are missing some photos potentially, but besides that, discovery is.
If you can try to get on it. 30 days, I'm putting this case to trial. Do you understand? It would behoove you to immediately go out there and start trying to find a lawyer. I'm going to have you go to Victoria, sign a reset. After that, you'll get with Felicia for your bond conditions. I'm going to have you take a seat while we create all the documents. We'll have you sign it, and then you'll be free to go, sir.
Yes, sir.
When the judge revoked bond after repeated violations and imposed scram monitoring, did the court properly apply Texas Code of Criminal Procedure Article 17.40 while remaining consistent with the Eighth Amendment's prohibition against excessive bail?
Yes, sir.
Mr. McIntosh, you're charged. You're on bond for a theft. You've now picked up a new theft. On the new case, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 6, 2025, an officer was dispatched to a shoplifting call at Walmart in Harris County, Texas. The officer made contact with the asset protection staff. The complainant stated that he recognized the defendant from a previous encounter. The complainant observed the defendant grab multiple items and attempted to leave the store, passing all points of sale without attempting to pay. Defendant stated he owned a Purple Heart Veterans discount and therefore the amount
That
stolen.
was the first theft, right? I remember that from the first one. That's 254, right?
Right, so, no, this is 255. So maybe similar facts.
Then that's the exact, then that must be the exact same as the first one.
Let me check. Right. Yeah, that's my thought. So the older theft is from December 16th, 2024.
Right.
And that was from Melrose, and this is from a Walmart, and this is on March 6, 2025. I'm not seeing anything on the previous theft regarding the Purple Heart discount.
Okay.
Would you like me to start over?
Just so it's Walmart and how much?
$283.62.
Judge, if you can recall, this is the young man that you had granted a pretrial you had given a bond for him. You had me to talk to his mother to see if his mother would have a place for him to stay. And she said yes, provided that he puts up an effort to try to get a job and et cetera.
Oh, I remember that. Okay. But he now picked up a new case.
No, he had.
Have we addressed that since the new?
Yeah, we addressed it. We knew that he had picked up another case. That's why you were upset that he had picked up another case while he was on bond for the previous theft. But the court was kind enough to still give him a bond because I had spoken with the mother, and the mother informed me that he could stay there and where until such time that he.
Are we doing another arraignment then
Right.
today?
Yeah, bond conditions have already been set for this.
Vic, why are we doing an arraignment? Is today just a regular setting then? I'm showing them both set for.
Door? Okay, yes, Judge, I guess it was just a regular setting. He
Don't-
had a PR bond, and on the
Right.
bond, it had today's date of billing
If you pick up a third case, I'm going to absolutely lose it. Do you understand?
Yes, Your
You
Honor.
must get a job or be in school full-time.
Yes, Your Honor.
Do not use any illegal drugs. If I find that you're using, I will lock you up. Do you understand? We've given you now 2 PR bonds on the first one, 1 PR bond on the second case. That's 3 PR bonds. You will not get another one. Do you understand?
Yes, Your Honor.
In the next couple of weeks, I'm going to send you for a drug test. If I find that you're using, it's not going to go well for you. Okay, so I guess let's set this case out for a couple of weeks because I want to know what he's done to get a job. I'm setting your case out for 1 to 2 weeks. I want to see what you have done to get a job. If you have done nothing, if you come here and show me that you have not filled out at least 10 to 15 applications for a job somewhere, it's not going to go well for you. You understand?
Yes, Your Honor.
All right, so 1 to 2 weeks, you're going to get tested when you come back.
Yes, Your Honor. Yes, sir.
All right, Mr. Lee, thank
Thank
you.
you, Your Honor.
Thank you.
Marcus,
Hey,
right?
Judge, yes, approach on Mr. Perez, it's an arraignment.
Page 20.
May I call him up?
Yeah, please.
Ricardo Perez.
Is this all you have today, Marcus?
No, I've got other ones I need to talk to you about.
What is the case number?
It is 255-6010.
Buenos días, señor. Nomás conteste.
Perez, you are charged with assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay. Hi, Atkins. Good morning.
On March 16th, 2025, officers were dispatched to an assault with injuries located at 4,000 Hollister in Harris County, Texas. The officers were unable to speak with the complainant because his injuries caused him to be unconscious. Officers reviewed surveillance, which showed that the defendant pushed down the complainant with both of his hands, causing the complainant to hit his head first on the concrete. It also showed the complainant to be unconscious. The defendant was identified through a witness who called him out on the scene and identified him. And the defendant matched the person in the surveillance footage.
Where was this? Is it at a bar? Are you drinking? What?
It doesn't state, it just gives an address.
I believe it was at an apartment complex where he resides, my understanding. I guess we'll see what the surveillance shows.
Mr. Perez, I'm going to find that there's sufficient probable cause to go forward with your case. I want you to understand that I'm going to do everything in my power to protect my city at all costs. This is now your second assault within the last 1.5 to 2 years. If I find that you so much as put hands on any single person, I'm going to lock you up. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they will put a detainer on you. Do you understand?
Usted lo entiende.
Yes.
Yes.
I'm ordering you not to consume alcohol, illegal drugs, or prescribed controlled medication. I'm going to write you. If I find that you're using, likewise, I will put you in jail. You're ordered not to have any contact with the complaining witness in this case, not to be in possession of any weapons, or not to go within 200 feet of where he lives or where he works. For now, I will have you go to Ramona, to Victoria to sign a reset. After that, I'll get you with Fleischer for your bond conditions. Be careful. You are skirting extremely thin ice. Do you understand? If that ice cracks, your butt's gonna freeze. Come on.
You want me to adjust my other, I have about 3 others. Jose Cruz.
Okay.
We submitted the PT application mitigation and the TRAS. We're just waiting on, he was approved, we're waiting on the contract.
Okay, so let's set it 2 weeks for you to get everything done.
Okay. Can I waive my client's appearance?
Yeah, if he doesn't have everything done though, then he's gotta be here because it's an old case.
Okay, he's here today.
Okay.
Okay.
I'll waive it as long as he's, got everything done. They're ready to file the supervision order and.
Okay.
Okay.
Next one is Guevara, Guevara, Jose.
Okay.
We're waiting on approval. We submitted the PT application and mitigation on Friday. This is the one that we had talked like a week ago, that we just found out he needed it, so we submitted everything. We're waiting on approval.
I guess let's do it again. We'll give it another week.
2 weeks?
No, 1 week.
1 week.
It's 250 days.
Okay, and then the last
Same
one.
thing, it'll be made if it's not, if it's not approved or denied by the next one, then I'll send an email myself because it's, yeah. Okay.
My last one is Diego Gonzalez. Again, same situation. Last time we were here, Judge, I was emailing back and forth with Ashley. Initially, she had said he's denied because he
Right, the
he
no
didn't have
insurance bit,
insurance. And I
right.
said, no, he does have insurance. And Geico's been trying to get hold of the CW. And even the DAs are having a hard time getting hold of the CW. So I'm waiting to hear from
I
her.
did give her, and you gave it.
I emailed her both. Yes, I emailed her the letter from Geico and insurance.
Let's give it a week also to see if she approves or denies.
Great. That's all I got. Thank you, Judge. May I be excused? Thanks.
This is an off-docket matter. It's just really quick that I want to bring to your attention. Jonathan Lopez, you scheduled him for a TRAS. He refused to do the TRAS. We're due back in court on Monday. I'm not sure if you wanted to put him on docket sooner to address it. Cause number is 255-5478.
It's the one you're on the BPO with funds, right?
Okay, no, just.
We're okay for Monday? Okay, I just wanted to bring it to your attention.
Thank you.
All right, thank you, Judge. Okay, thank you. May I be excused?
Was that it for arraignments, or do we have more? Do you know?
Judge, I'm not sure. Who's the last one? Judge, if you talk to Perez, Ricardo Perez.
We just did that one.
Yeah, we just did.
Yes.
Okay, I think that's all they were.
Ms. Perkins.
Good morning, Judge.
Good morning.
Hi. I have Mr. Christopher Allen on docket. The state just filed a dismissal on his case. I just want to let you know.
State what?
Filed a dismissal.
Got it. Okay, I'll sign it for you.
All right, thank you,
Is he
Judge.
here or no?
Yeah, he is in the gallery.
Got it. Okay, we'll give him a copy then.
All right, thank you, Judge.
Yes, ma'am.
Alrighty, have a good one.
Miguel?
How many do we have? Morning, sir. Good morning. Do you have a lawyer today?
No, sir. No, Your Honor.
You have the ability to hire a lawyer?
I do. The only thing is, they're way more expensive than it would be to just pay off what I owe the county.
I mean, how much does he owe? It's a theft by check.
$141 in the, oh, wait, no. So one check was written for $1,377.63, and then one was written for $141.13.
HEB?
The tax assessors, Harris County tax assessor.
I'll give you a lawyer today. That way you don't have to just start wasting a bunch of money. Do you mind appointing a lawyer?
Yes.
So just hang tight. I'll give you a lawyer here momentarily. Okay?
I'll get on
Please.
this side a little bit.
Yeah.
Right this way.
Did you put an offer on the case?
There is no offer on the case
Do
yet.
you mind?
Yeah.
Please. Good morning, Mr. Wilson. Do you have a lawyer today?
She just reached back to me this morning, so she told me she's gonna contact me this evening when she get done with court.
Hired her?
I just got in touch with her. Like, I've been reaching out to her, but she just responded.
Okay. Do you want more time?
Yeah.
Okay. Head on over to Victoria. We'll give you more time. Hi, ready?
I sent you an email on that. Tanya? Yeah. We had addressed it before. Yeah, it was, you sent him to get a drug test on the first BVR. And then it came back positive for opioids, I think. And they said they wanted to send it to a lab. I provided a list of the medications. And then they submitted that second BVR with all that stuff and saying that he did provide his list of medications.
For who?
Janiel.
Oh, Montanel?
Yeah, yes,
Was it Montanel?
yeah. Martin does not do it.
Yeah, so we were waiting for the lab results to come back and they have come back.
We knew there was a presumptive positive.
Is the presumptive came back?
Here she says some positive for alcohol, right?
No, just opioids. It's a he.
Oh, I was thinking someone else. But one of those that she's taking is positive for.
I think several of them do. And just a presumptive look at it, when I first looked at it, it was the antipsychotic ones that would get false tests, as far as that's concerned.
Is there just no one at pretrial that can address
None of
this?
us that know.
Not you guys. I know you, but there's no like.
No, we would have to, not even our drug technicians. I reached out to my supervisor regarding it, and to confirm that, we'd have to get someone who's certified or someone from Abraham.
Okay, I'll speak now then. Let me reply to all you guys, and then I'm gonna bring someone else in as well. See. So I'll send this email, and we'll just stay in touch, and then we'll see what they say.
Okay.
I'm gonna reach out to the higher ups to see, hey, do we have any? I mean, I can't believe that we don't have anyone that would be able to.
Say one way or the other.
Right.
Yeah.
You know.
I'm trying to pull up the picture I have, but it won't pull up for some reason. But yeah, there are I think one or two of the medications that he takes can give presumptive false positives.
If that's the case, then of course we're not going to do it.
Right.
See,
Okay, so do you want to leave them off for Friday or do we want to just hold off?
let's hold off on
Okay,
the original date for now. Let me see what.
see what they come, okay. All right, sounds good.
She's already. She can handle. Hi. Is it going?
Monday?
Yeah. Apparently you sent my client to go pee somewhere.
She didn't like to go.
I didn't want to be crass, but that's the fact.
No results of that, Judge. She hasn't provided a sample yet.
We've had a lot of history with her.
I saw that. I got emails on Friday about it.
Had, quite a bit of history.
Third bond violation. I saw that. Do you want me to recite it out of my memory?
That, we've had quite a bit of history. Does she not have a prior case with us too? Is this?
21. I don't think she does.
No.
Is this the one where there was an issue with a boyfriend and?
There is a boyfriend in the car, and the really interesting thing about this is like the police officers did a full felony stop on a DWI with guns drawn, making them get out. It's kind of weird.
Capital?
It was really strange. I'm watching it going like,
Capital DWI?
that's what it was. Of course, it was like precinct 4-ish. Everything up there could be a capital in their minds, And so I don't know what you want to do with this judge.
Just don't want her using, that's it.
I get you.
That's all I want. I want to ensure that she's married. So,
Judge, and then also we have the English interlock that she's not getting, so we're not monitoring her by any means. Because she had the portable first, we had portable violations, so then she was revoked. Then she provided proof that she had gotten her vehicle fixed, so we swapped her over to the ignition interlock. The ignition interlock is not being used.
so let's see how it goes today. And then I'm gonna random her again. So, if she tests positive, then we'll see. I don't know.
I mean, do you want me to wait? I'm perfectly willing to do that.
Oh, and then I'll get a hold of you. Or you know what? I don't have your new number. Do you mind?
I need my new work number. My old number is still the same.
Oh, is it really? Then hold on.
You have it for sure.
Yeah, I know. If it's the same one, then don't worry about it.
Yeah, it's the same.
5-6.
I don't give that out to anybody. That's me. That is me.
Okay, so I'll text you. And then
But do you want me to come back if there's an issue?
you can always Zoom.
Okay,
Zoom.
perfect. I'm gonna go straight to my office.
Go. Hi, Joe. How are you?
Jones asked by according to Courtroom Espinosa, or this is on the docket, PWI case, clients here. We are still waiting to hear about whether PTI is going to be approved on this.
Everything's in, Judge. We're just waiting to hear back about the approval.
Okay. I guess let's give it a week, Joe.
Okay, sir.
If it's approved, I'll waive, and then we'll set you off like a couple weeks for you guys to get the contract, get the, portable and all that jazz. If it's denied, it's got to be here so it's.
Okay.
Yeah. Thank you. Okay, for sure. Have fun. Ready?
Good morning, Your Honor.
Yeah. What's up?
I am here on Mr. Mark Gurley's case, who's on docket today, Judge, Gurley. And initially, I'll wait till you find it, Your Honor.
Thanks. Gurley?
Yes, sir.
Okay, I see it.
So initially, I had brought up some concerns that I had with the accuracy of the DIMS report and accuracy of the information that was being alleged within the four corners of the probable cause hearing information, I guess. And so you had set this.
As far as probable cause?
Right, yeah. As far as
you want to redo probable cause?
Well, we had heard probable cause, and within the four corners of the DIMS, you had found that there was probable cause for the case to continue. But the issue that I had.
Can I do it again?
Well, I mean, I'm just kind of bringing you up to speed again, Your Honor, because I know it's been a few weeks. So the issue that I had raised at that time was I did not believe that that was accurate. The state had conveyed videos to us about, what the officer had seen from the dash camera perspective. And so I had issues with the accuracy of what was contained within the DIMS. I've spoken to the state this morning, and she said that she's reaching out to the police officer to find out, I guess his side of the story is my understanding. I don't want to speak for the state.
I've watched the camera footage. I just want to speak to the officer before we make any decisions on the case.
The issue.
The issue is that from what I can see, I don't want to get into the facts of the case right now in front of you, Judge, too much, but.
Then don't.
Right.
Then don't. Just do what you need to do.
Right.
You want, it's only 25 days old.
Sure.
I just emailed him today. Yeah. I think a regular. Yeah.
Sure. It's a very new case. If I can get maybe a couple of weeks, Judge, I've got.
You can have as much as you want.
Sure.
It's up to you.
Yes, sir.
I guess if you just set it, if you need me to do another probable cause hearing, I'm happy to do it.
Sure.
If there's something that has come to your attention that's not right in the DIMS, I'm happy to hear it and we'll redo probable cause. I'm happy to do it at any time.
And maybe the state's conversation with the officer will clarify all of this and then.
Yeah, absolutely.
All right. All right. Thank you.
I'll grant it for you.
Okay. Excuse me. Thank you.
Hi, Judge. How are you?
Good
to see you,
It's been such a long time.
I know, I'm back.
What's new?
I had
Thanks for the warning.
kids. How are your kids?
And maintenance.
How old now? How old?
14, 12, 9, 3.
There's 12 or 14 girls?
Well, a boy and a girl. We put them to work.
A real girl?
Girl.
God bless you in every way there is.
She's great. I love it. I'd have more if I had none.
Real girls, just you, right?
She's so sweet. Great.
We've been there. We were 12-year-old, 13-year-old, 14-year-old girls.
It was rough for 12.
They're hard.
It's okay.
They come out of it.
Yeah. You can't just give it time patience, you know?
I have Miss Bookman, who's not on your docket.
Okay.
She was here on Friday, and she's hired me on a DWI, and she has 2 trips planned, and she has to do UAs. One is out of the country, one is not. How do you handle that?
So typically, if they're out, we have them, if they're in the United States, we have them go to like a quest wherever they are.
Okay.
They get called on to do
Okay.
this. Get the results you get to us, we're happy.
Okay.
If they're out of the country, how long?
She'll be out of the country for 5 days.
So let her know.
Yes, to her.
Let her know not to use. She's going to get tested as soon as she gets back, just so that she knows.
Okay.
So just let Lisa know about the date so that for the out of country ones, so they know not to call.
Okay. Perfect.
Yeah, that's it.
Thank you. Shit.
Have fun.
Hi, Shrey. I'm just here for Mario. He's got Christopher Torres, who is surrendering himself today. I believe papers are filed and everything. But he had, and I'm a little unclear on the details because I wasn't here, but he had brought an AA log that I believe you were gonna, if he had shown you that.
Well, no. I said be creative with what, and I would consider waiving the fee.
And so he's given me an AA log. All right, give it to the court all the time. See, he's gone almost every day. There were some wildfires that he had to be evacuated from. So that's the only day or a couple of days he was Torres, and Mario's off picking a jury across the street. Otherwise, he'd be here himself.
The reason I had the problem is because he has a prior intox assault where there's like, and now we have another second.
Understood.
So that's the problem I had. And I was hoping more than just 11 classes. Okay, here, let me give that back to you. Christopher Torres, come up. So, Mr. Venus, correct me if I'm wrong.
Sure. Yes, Judge. Yes, sir. Be as much of a help as I can.
On a sentence of 10 years in prison, probated for 10, can that be used on a third degree to enhance to 15 to life?
If the probation is successfully completed, no, for enhancement purposes. It could be for jurisdictional purposes, to make under 4904 or whatever it is, to make it would count as a previous conviction for those purposes, just like an assault family member, even a deferred adjudication would count to make a second.
My curiosity stems from because with his intox assault, he was sentenced to 10 years, probated for 10 years, and it looks like he may have completed successfully, but it's still a felony conviction, right?
Correct, but it's not, you can't use it to enhance punishment ranges, essentially. It could be a jurisdictional paragraph, but not an enhancement paragraph, if that makes sense.
My concern, Mr. Torres, is you're now pleading guilty to this DWI second. The problem is that if you pick up another DWI, from now on, you're facing a third degree felony. You're looking at 2 to 10 in the penitentiary. And I don't know if they can use that intox assault conviction to enhance you to an even further penalty, a further consequence. I mean, that's why I'm asking you. I don't know. I know misdemeanors, but the problem is that with a felony conviction, they can use it to enhance punishment. Perhaps it's a 15 to life next time you pick up another DWI. I don't know. But do you want to take that risk? That's the problem. I mean, imagine all this that you've suffered now, and we're here yet again. What's it going to take? A death? Well, I know you say no. Everybody says no. If I had one strand of hair for every time, I'd have a nice looking head of hair. You're facing up to a year in jail and or a $4,000 fine. What are we doing? You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law, and you give up the right to appeal. Once you accept this agreement, it will go on your record. It will be there forever. And I'm telling you now, your record, it's not a good thing. You get pulled over, even with the faintest smell of alcohol, you're going to be charged with a felony. Do you understand? I wouldn't, even if you've had a sip of alcohol, I wouldn't get into a car. So, he goes in today?
Yes, sir.
All right. I'm going to waive the fee because you're going into jail now. So I'm not going to tack it on, but stop. Don't kill someone. This weekend alone, 3 people died on our roads this weekend. This weekend, 3 people died. It's not hard. Just don't get into a car. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty, sentence you to 50 days in jail. I'll give you credit for the 2 days that you've done. I'm going to suspend your license for 1 year. Do not drive until you get a license, and then we'll take him into custody now, and I'm going to roll your court costs so you won't know anything. All right?
Thank you, Judge.
Good luck. Thank you. Great to see you, man.
You too, Judge.
Too serious.
Hi, guys.
Hey.
Morning, Judge.
Hi, Judge. Same old, same old. We're here on Miss Gillis.
Thought I had it open. I closed it. All right. So Judge, she's one at Pennsylvania for theft by deception, false impression.
False impression.
So this one will be asking for no bond on the extradition because over the course of 6 times, she stole $780,000 from an elderly, and it shows from the hit that she's an international flight risk with a non-American passport.
That's the first time I've heard that. An international flight.
That's what it
flight
shows
risk.
on the
Is
hit.
Interpol involved?
Well, so that's why I was surprised because this was a DHS referral. I was kind of surprised there wasn't a nice hit because she's not a citizen and it shows. So I don't know.
The bond?
Check.
I want a PR bond.
PR bond. Okay, so let's bring her out, please. Gillis, if you don't mind. Yeah. Joe, you want to talk to me while we wait? Ms. Gillis.
Yes.
Good morning. So your lawyer is asking for me to set you a bond. I don't know. I've never met you before, and I have about 5 minutes to get to know who you are, to see whether it would be right to set you a bond. I have no idea what you're charged with, but the problem is that you are an inherent flight risk because you're wanted out of another jurisdiction. There's a warrant in some other state, and we got you here. Mr. Kim.
Your Honor, around October 31st, 2023, it's alleged out of Pennsylvania that this now defendant manipulated a bank to over 6 transactions, caused a total loss of $780,000 to an elderly individual from the retirement fund. There has been regarding the affidavit, when speaking with the complainant, states that the checks for the individual were mailed out to her name with the corresponding physical address. On notification from DHS, it shows that she is an international flight risk, and due to those factors, the state would be opposed to a bond for the extradition.
Why would the Department of Homeland Security say that she's an international flight risk?
I'm not sure. I can reach out to them, but obviously if I reach out to them, I can reach out to DHS and ask why. I only get the notification, and so I haven't spoken with an individual. But
what other criminal history does she have?
She does not have any others, just the 6 incidents arising from this affidavit.
I can clarify. It's possible. I believe they think she's an inherent flight risk because they arrested her at an airport on a connecting flight, which sounds terrible, doesn't it? You're thinking, oh, she's leaving the country.
Really? Was she headed out of the country?
No, really. She was going to Jamaica. She's from Jamaica. She comes back and forth for business. She's got an H2B, something about H visa. And her father is a U.S. citizen. Here's the kicker, Judge. She gave birth January 30th of 2025.
Okay.
She's breastfeeding. So when our lovely county got her, they said, too bad, so sad. She's been in custody for 4 days. They refused to give her access to a pump. She has asked for a heating pad to do it herself. They've only given it to her 2 times.
I mean, we'll see about. I'll reach out to medical.
this is
Don't worry about that. I'll reach out to medical.
That is insane.
Yeah, I know
But,
it sucks.
Like
And
6
that can
days
happen.
later, and I'm like, she was clearly arrested with her child. Okay, so it's not like she's lying. But I just think because of that, let's add some other things because that by itself is like, oh, that sucks for you, right? But it's a 2B. It's not like she's a flight risk. It's not like she's a failure to appear. I get that it's like a theft by deception because of some bank mailing thing. She's never given an opportunity to go turn herself in. So I think that considering the fact she's never had an opportunity to turn herself in, this is not where she's just like running the country. She comes here back and forth. Her child is born here. Her father lives here. Connected with the fact that she has some problems going on with her 1-month-old that she's going to have to figure out. I'm asking for a PR bond. I'm asking to give her a chance. We've already done her wrong.
Before I give her a PR bond, I would like you to figure out why they're saying that.
For the international flight risk?
Yeah.
I'm more than willing to.
Not only that, but you're telling me that she does this all the time? Let me see.
Do you go back and forth? You can tell the judge yourself.
I have a travel visa. I have a visiting visa for the US, which is a 10-year visa, and also have a H2 visa, which is a work visa. I worked in Utah. I worked in South Dakota, South Carolina, Massachusetts, Florida for the past 5 to 6 years, back and forth. And I also do extensions.
Prove all this.
Yes, I do. The currency office do have my passport with my visa currently stamped in it.
So let's do this. Let's roll it to tomorrow because I don't think now it's wow, is it already 11:30?
Yes.
Holy moly.
So they do have it downstairs in the old.
Tomorrow, I want proof that she does all this this international travel routinely, so we know that she's not just trying to take off.
No, sir.
And then I'd like you to reach out to them to see why is she international flight risk. Is it a 2B?
It is.
You know, I'd like to know how they justify saying that, right? Or do you just think because she's on a flight now?
I don't know.
That's why.
I'm perfectly willing to call. I'm just obviously aware of making the call to DHS regarding the pending Pennsylvania charge. Yeah, I've always got the trigger, so. Because she doesn't have an accident right now, but because she's on a visa in terms of what they decided to vote.
This is crazy.
So like I said, I'm willing
Then
to.
ICE is gonna put a hold on her.
That's what I mean. It's like
ICE is going to do it regardless.
ICE is not
If
gonna
she-
hold-
No. If she's here with the proper documentation, they're not going to put a hit on her. If she's here with the visas, then there's no reason for her to put a hit.
Judge, they're deporting students nowadays, but hey, that's okay. All right, I'd like to put you on the email with medical about the breast pump. I find that outrageous.
Yes, I will help you with that. Don't worry. But I'm not prepared to set her up on yet with Mr. Kim saying the international, and then she's on a flight to Jamaica.
We'll get the proof. I'm gonna have to zoom in tomorrow though, but I'll get it handled.
Sure, of course.
Yes, Judge.
How are you, Judge? Good morning.
Good morning.
Still, yes. Judge, I'm here on Jesus Figueroa. It's approaching on a plea. You're on?
Okay, are you ready? Oh, it's a second DWI? Is it a true first?
It's a true first.
Okay, I'm okay with it. Come on. That's why I was that. Okay. All right. Good morning, Mr. Figueroa. Good morning. Sir, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. It looks like the state is going to reduce that, take off the enhancement. So now you're facing only 6 months in jail and or a $2,000 fine. You've worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you have done. You need to understand that this charge will now go on your record as of today. It's going to be there for the rest of your life. What we're doing today, from now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. No more proverbial slaps on the wrist. Do you understand? You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, there's no turning back. Do you understand?
Yes.
This is what you want to do.
Yes.
How do you plead to the offense of driving while intoxicated? I'm going to find you guilty. I will follow the agreement, sentence you to 3 days in jail, grant you credit for 2. I'm now going to suspend your license. I have to. I'm going to suspend it for the minimum, which is 90 days. From now on, you get pulled over. An officer's going to see this. Even the faintest smell of alcohol, dope, anything, you're going to go down. So don't get into a car, even if you've had a sip. You understand? Yes. All right. Good luck. Thanks, Josh.
And we filed a DPS waiver search.
I'm going to waive your fines and fees that would normally be $4,500. That's what you would normally owe with a case like this. You pick up a second DWI, it's $6,000. Do you understand? Yes. And a minimum of 30 days in jail. Get the clue. All right, good luck. You can, thanks.
Judge, I have another case. Last name is Said, S-A-I-D. I'm here, Attorney Russell Newman is in trial. He wanted me to take care of this case, but he's not present. He's not here today, Judge.
I'm going to end up revoking it then. He was supposed to go.
Yeah.
Well, let's see. Do you know Saeed? Did he show up?
We got notification that he did not.
Got it. Okay. I'm going to end up revoking it.
Something his father has been in touch with me.
No, he's supposed to be here. This is the second time we've done this. The case, it's
old. Yeah.
No, it's 250 days old.
Okay.
He knew it because I admonished him.
Right.
Ad nauseum last night. Okay. So
we'll see what we can do with it, Judge.
All right. Thanks.
Thank you.
All right. 5,002 on both.
Is this the one from last week?
Did you get it done?
We did. I just heard we got denied for a PTI. Yeah, I'm shocked. I thought it was a good mitigation packet.
Just due to the accident and the details of the driving fast, he was denied.
What do you want to do?
I'd like to set it for trial. Well, actually, I'd like to have a compliance hearing. There's some discovery that is missing. The state brought it to my attention. I'll let the state.
It's a so there was multiple agencies on the scene. It appears that we only received discovery from one of the agencies and the other agency did not submit discovery to us. I have watched the footage and I've been able to identify the other officers on scene and I've been in contact with them. I just haven't received the discovery yet.
How long do you think, have you spoken to them or no?
Yes, I've spoken to the,
What did they say? Do they have it?
they would need to look. I think there might be an additional offense report out there and I think there might be an additional body worn camera.
Okay, so let's do this. Let's do this. I'll set it for a compliance hearing on Friday. Subpoena the off, well,
I mean, you're judging, if we don't have this by then,
I mean, yeah, the case is like,
case, right?
you know,
This has been an issue I've seen with this particular agency.
what agency is it? What the flip?
I've seen it where their system goes by offense report number, but sometimes they may have a different offense report number. So then when the body worn camera comes back, it tracks to a different number. There's a way that HPD can pull it up by their own name and badge number, but we don't have access to that. We just pull it up by the office report number. I've seen that in felony. It's bit me in the behind before when I was in trial where, you just don't know their body came from.
Okay. I mean, I guess Friday. Blaze, what do you think?
I mean, it's been
261 days.
I think if we are telling the officer, like, you need to have it by then, I'm hoping the headlights will fire.
Okay, Friday.
I have a scheduling issue for Friday, Judge.
Zoom in.
I can zoom in. Well, what if he's going to do a plea? Well, I guess it's, we'll see if it comes.
See if it comes.
Yeah, I think they may dump it.
It's.
Okay. Can I wait my client's appearance though? Okay. Thank you, Judge. I appreciate it.
Listening. Good morning.
Good morning, Judge. I was here on Friday on two cases, which is Manuel Cooch, COC, and then CUZ.
Yes.
And he's in custody, Judge, but right now he's in the 177.
Okay, we'll roll with tomorrow.
Yes, sir. And then another defendant is Neil White, and he was in custody and being processed on Friday, but it appears he made bond over the weekend, and he's not here, Judge. And he's got a bond violation, Mr. White bond violation report, and the state has filed a motion to revoke and raise. And he didn't check in, Judge.
PR bonds on all these cases.
Neil?
Make sure it's White is in custody, right?
No.
No, I don't.
It's both said he's in custody.
At you going? You got Neil White? I'm showing bond made.
I'll double check. Yeah, the anthem separate by us, so you make sure you get.
I mean, he's supposed to be here for these cases today. I mean, I guess maybe they get him a 7-day setting. I don't know.
And then you need another shirt.
White.
They just had to get the next, yeah, I just.
So what's probably going to happen is he got a 7-day setting.
He's got what, Judge?
He got, when they bond out, they get 7-day settings normally. Okay. I'm assuming that they probably gave him 7-day settings on everything. What I'd like to do is put him on for Friday. So if you have a good number, please reach out to him and let him know that we're going to put him on docket for Friday. He has to be here. Okay.
And the other gentleman carried till tomorrow. Thank you, Judge.
I'm focusing on off docket matter.
Okay.
This is for, cause number is 2535421.
On Ms. Treadwell.
Ms. Treadwell.
Okay.
Yes, Your Honor. So we are close to getting an agreement. However, I wanted to revisit, Your Honor, on this. Well,
no, I know what you're going to do.
No, Your Honor. It's more so of, we're not trying to get out of inpatient. That's not what she's trying to do. Okay, she's been working with the WHO Santa Maria for the past 2 months now, and they've been sending me all letters and everything. I just had not had a chance to send it to state. They offer the type of facility that you can bring her children, and that is much more so what we would want to do.
I don't know. Did they recommend Hue?
They did.
I'm okay with Hue.
So.
From my understanding, Santa Maria is for small children, pregnant, is she pregnant or?
No, but she has a small 3-year-old, and she's 3 years old. And she's 3 years old, autistic. You know, she is.
I'm okay with Hue Santa Maria.
Okay, you're okay with WHO Santa Maria. Okay, there we go. That's what we do. Okay, all right.
Absolutely.
Thank you. I didn't want to know so fast.
No. I want to make sure that it doesn't, if they're okay with the Santa Maria, I'm okay with it too.
Okay.
Yeah. Totally.
All right. Thank you.
Yes, sir. Oh, this is what you were asking?
Yes.
Mr. Anthony Lopez.
Yeah.
It seems like he needs to pay out of pocket 1,500.
Okay.
So could we get 30 days, Your Honor?
Once time served.
Yes.
How much do you want?
30 days.
Well, I'm not going to do 30 days. This case is 210 days old. I mean, this should have done a long time ago. I'll give him a couple weeks, but Michael, that's right. So here's the deal. We don't, you got to understand that the business that we're in, we don't trust people, right?
Understand.
We got to have this stuff up front because we've been burned plenty of times. So if that's the route that you want to do, take the time served, you have to pay restitution first. Can you generate the bill if you don't mind?
Yes,
That way
it's
we-
already generated.
We can give you the bill to you. I will give you 2 weeks. The case is 210 days old, so I'm not giving you much time. I'll give you 2 weeks. If you've got it paid, great. If you don't, we can do a probation and then you can pay it as while you're going on the probation. So don't stress. If you don't have it, then, don't do anything you shouldn't do, right?
Yes, sir.
At the worst is the worst, we can always do it through a probation. Okay? You got 2 weeks.
I can get it done.
Okay. All right.
Thank you, Your Honor. And then I have Mr. Louis Lemus, Your Honor.
Okay.
We submitted a mitigation packet. Ashley's waiting to see if that's proof for cost before she makes a decision. Can I get a week or so?
I mean, all he has to do is get proof of college, right?
Yeah.
Literally, that's something that you can just pull up on your phone and email. I'll give you till Monday.
Yes, sir. Thank you, Your Honor. Thank you.
Good morning, Mr. Frazier. Do you have a lawyer today?
So I do not.
Do you have the ability to hire a lawyer?
So,
Okay, I'll have you fill out an application. I'll take a look at it. What are you doing with yourself these days? Are you working?
yes, sir. Just doing the work.
Okay.
Thank you.
I'll have you fill out an application. I'll take a look at it.
Say again?
Shh, please. Thanks.
I'm gonna give him the sign.
If you look on the TV, this is the lawyer that's been appointed to represent you, Mr. Pruitt. It is your responsibility to stay in touch with him. If he tells me he cannot get a hold of you, if you pick up a new case, if you become a danger to my community, it's just not going to go well for you. Do you understand?
Sir.
I'm not asking much. All I want you to do is be a productive citizen. Do as much as you can to help out everyone and be nice. Do you understand?
Sir, no
Okay. So, Deputy, do you mind getting his cell phone number? Do you have a pen? I need you to write down your cell phone so I can give it to Mr. Pruitt, and then I'll have him reach out to you here momentarily.
Judge House, May 6th through the 8th.
May 6th to the 8th, Carl. Thanks, Deputy.
May the 8th is good.
While you have this lawyer, Mr. Frazier, I will waive your appearance. Is that a 3-2 at the end or 3-3? 3-2?
Put the 532.
Well, he's your lawyer. I'm going to waive your appearance so you don't have to waste your time coming to court. But you got to stay in touch with him. You understand?
Sure.
Okay, I've texted you to the cell phone. We'll have you sign your reset and then you're good to go. Okay, good luck, Mr. Frazier.
Thank you, Judge.
Thanks, man.
Are you texting it to me or are you putting it in the?
I chatted it to you.
Oh, chatted. Okay. Good
Yeah,
enough.
so take care. Look at the chat, okay?
Gotcha. Thank you.
Are we doing a plea?
Yes, Judge, but just want to make sure we do waive the DPS fine for Mr. Garza.
Is it a first or is it a second?
First, Judge?
Yeah. But let's get this done because I need to take off.
Yes, Judge. Sorry about that. I was in felon court.
Don't worry about it.
Okay. Mr. Garza, come up this one? Can you get the waiver? Yes, I'll do that right now.
You now have 2 warrants for your arrest for failure to abide by the bond conditions for continually picking up cases. So we're taking you into custody now. You have the 2 warrants. So he goes with you.
Big constitutional question. Does a strongly deterrence-focused judicial approach during repeated plea proceedings remain fully consistent with the Fifth Amendment requirement that guilty pleas be voluntary and free from coercive judicial pressure?